Okie doke, right, I think that's probably most of the people joining that are here. So just a quick introduction from me. My name's Laura and I'm one of the CoP team at Spire Barristers. We've got a growing team of barristers who are specialists in court of protection law, and our practice covers the north of England and is ever creeping a little bit further south. We are one of the few chambers outside London to have a truly specialist team, and we are always happy to help with any queries. So my presentation today is all about where the land currently lies with protected parties and their access to sex workers. It's been the subject of 2 judgments in the court in recent years and an issue which is in many more that are yet to come to a conclusion. And the second half of today's webinar is going to be from Jade Price from PSG Solicitors in Manchester, which is about settling outstanding care debts and safeguarding assets. So I'll hand over to her at about 1:30. If anyone has any questions, could you pop them in the chat and we can look at them as the presentation goes along and hopefully answer them as fully as possible. There will be an email link to the recording of the webinar, and the slides will be circulated to all the attendees probably tomorrow. So I will now just attempt to share my screen. If anyone can't see it, please bob it in the chat function and I'll try and fix whatever technical nightmare I'm having. Okay, hopefully that has come up and we'll get going. So this presentation does come with a health warning. The law on this point isn't settled yet, so this is very much just a working position on where the case law is up to. There are 2 conflicting judgments from the High Court as to the scope and reach of Section 39 of the Sexual Offences Act 2003, and I'll deal with both of those judgments today. Permission has been granted to the Secretary of State to appeal the decision of Mr. Justice Hayden in the matter of Re C, which is the judgment which goes into much more detail about the scope of Section 39. So turning first to the criminal law, there are 3 relevant provisions in the Sexual Offences Act which impact on this area. The first is Section 39, which governs care workers and inciting sexual activity. Section 42 deals with what the meaning of a care worker is, and Section 53A criminalises the payment for sex from a prostitute who is subject to force. So let's deal with what constitutes a care worker first. Person A needs to be involved in the care of another person, B. A is whether or not in the course of their employment a provider of care, assistance or services to B in connection with B's mental disorder, and as such has had or is likely to have regular face-to-face contact with B. Practically, this actually encompasses the litigation friend and the social worker, so it isn't necessarily limited to just the people providing care to P on the ground. So now that we know what a care worker is, if we go back to Section 39, in order to commit an offence, the care worker must be involved in B's care. B must have a mental disorder, and A must know or reasonably be expected to know that B has a mental disorder, and A must intentionally cause or incite B to engage in a sexual activity. Section 53A criminalises the payment for sex from a prostitute subject to force. And this provision is clearly intended to protect those engaging in prostitution from exploitation and people trafficking. And it criminalises the purchasing of sexual services from anyone who is not entering into that agreement willingly. The actual payment for sex that doesn't fall under Section 53A is currently legal. It's always therefore going to be challenging to distinguish when sex workers fall under Section 53A, and it presents another hurdle to this already complex question when we're looking at the realities of care planning around it. So the Mental Capacity Act 2005 obviously governs the jurisdiction of the Court of Protection. I anticipate everybody attending is likely to be familiar with the provisions, so I'll keep it brief. Section 2 sets out the framework for individuals who lack capacity, and we know that at the material time a person will lack capacity if he is unable to make a decision for himself in relation to a matter because of an impairment of or a disturbance in the functioning of the mind or brain. Section 3 governs the inability to make a decision, and this encompasses the functional test of capacity. So a person will be unable to make a decision for himself if he is unable to understand the relevant information, retain that information, use or weigh that relevant information as part of the decision-making process, and communicate their decision. So turning now to capacity around engaging in sexual relations, because that really is the first big question before we're looking at P and accessing sex workers. So capacity to consent to sex and capacity to make decisions on contact are determined on different bases. Capacity to consent to sex is general and issue specific. The relevant information for that decision was recently revisited in the case of JB, and the test as it stands sets out that the relevant information is the sexual nature and character of the act of sexual intercourse, including the mechanics, the fact that the other person must have the capacity to consent and must consent before and throughout the activity, the fact that P can say yes or no to having sexual relations and is able to decide whether to give or withhold consent, that a reasonably foreseeable consequence of sexual intercourse between a man and a woman is that the woman will become pregnant, and that there are health risks involved, particularly the acquisition of sexually transmitted and transmissible infections, and that the risk of those infections can be reduced by the taking of precautions such as the use of a condom. What is not relevant is the identity of the sexual partner, an understanding of what is involved in caring for a child, the risk that may be caused to a woman through pregnancy or risk to future children, the fact that the opportunity for sexual relations with a specific partner will be limited for some time to come into the future, and the ability to understand or evaluate the characteristics of some particular or intended partner. The Supreme Court heard the appeal of JB last Thursday, so everything that I've said to you there might change depending what they say, but as it stands, that is the most up-to-date position on capacity to engage in sexual relations. So assuming we get over that hurdle, the next question for any practitioner looking at whether P should be allowed to access sex workers is his or her capacity to have contact with sex workers. This is a bit more complex. There are two schools of thought on the test. Some case law suggests that it should be person specific. The official solicitor prefers others as a more general category, but on the ground and depending on the case, the reality is that the appropriateness of which approach is taken will very much depend on the facts of an individual case. The cases dealing with contact with sex workers so far have dealt with sex workers as a general category and not as a specific identified sex worker. There's no definitive answer at the moment as to the appropriate relevant information for this assessment of capacity, and the courts have not been asked to make any determinations as yet. In both the cases that I'm going to deal with today, it was agreed by the parties as to what relevant information should be put to P as part of the assessment, and the experts' conclusions were all agreed. So the court didn't need to consider the detail of the relevant information put. So in REC, the following information was agreed upon by the parties as being relevant to the decision. The risks associated with engaging the services of a paid sex worker, the risks that P may pose to the sex worker, the nature of a contract for services arranged with a paid sex worker, the nature of the relationship that P would have with the paid sex worker, and the reasonably foreseeable consequences of deciding whether or not to engage the services of a sex worker. So now that we know what the position with capacity is, I'll move on to the case law. The first case that tackled this as an issue was the case of LCC and Mr. AB. This case continues to rumble on with the theme of sex workers as a background issue. There are some details as to Mr. AB on that slide. He is a gentleman in his 50s. He has a diagnosis of moderate learning disability with a number of other comorbidities, and he has a 24-hour package of care in a bespoke placement. He had previously been assisted by the local authority, albeit indirectly, to engage the services of sex workers both in the UK and abroad, and he wished to do so again. The local authority had concluded that they would no longer facilitate this access, and a court application was made both in relation to that and to authorise the deprivation of liberty that was going to arise out of his placement. The relevant tests for capacity have evolved somewhat since these proceedings, which were in 2018, and it's anticipated that Mr. AB's capacity is going to have to be revisited. So there may still be some case law that comes out of this once that has been looked at again. We were before Mr. Justice Kean in that case, and he was not asked to explore the criminal law in detail, and as such, nor did he determine what the scope of Section 39, and in particular what cause or incite would mean, as Mr. AB was deemed to lack capacity to have contact with sex workers in any event. So it was very much a hypothetical question in this case, and it was agreed by all the parties that pursuing it on a point of law actually wasn't in Mr. AB's best interest. So the court wasn't asked to go into any real depth, as Mr. Justice Hayden did in the case of REC. Nevertheless, Mr. Justice Kean did make it clear that he did not consider it would be in Mr. AB's best interest to have contact with sex workers for 3 reasons. The first was that in his view, any carer that supported Mr. AB to do so would be at risk of prosecution. It would be contrary to public policy, and Mr. AB did not understand or accept the implications of having sexual relations with a sex worker. Now, arguably, the first 2 points of his reasoning aren't relevant to Mr. AB's best interests and should not therefore have formed part of that analysis. And whilst there's no doubt that engaging the services of a prostitute who falls within the scope of Section 53A is a criminal offence, the court didn't consider the circumstances in which a sex worker is offering his or her services of their own free will. So that case probably posed more questions than it answered. And when the matter finally came back before the court, it was Mr. Justice Hayden that was asked to deal with it in more detail. So the case of Re C had more input from external parties to help Mr. Justice Hayden undertake a more meaty analysis of the law. The court had evidence from the director of the Professional Deputies Forum, who confirmed the engagement and payment for the services of escorts for clients was recognised practice by professional deputies. Professor Detan, the chair of the Outsiders Trust, which is a charity for people with disabilities, which focuses on education and support for the provision of sexual and intimate services, also provided information. And she confirmed that all sex workers associated with it within that charity are vetted. And they also had the benefit of evidence from some leading criminal silks who advised that it was highly unlikely that the CPS would choose to prosecute the carer in the circumstances contemplated in C's case. She did conclude, however, that any person directly or indirectly supporting C would be causing for the purpose of Section 39. So the situation that C was in was that he had capacity to make decisions about contact with sex workers and to consent to sexual relations. He had expressed the view that he wished to engage the services of a sex worker because he considered that trying to find a girlfriend would be too big a challenge. So the issues before the court were whether a care plan to facilitate C's contact with a sex worker could be implemented without the commission of an offence under the Sexual Offences Act. If not, whether the Sexual Offences Act can be read compatibly with the European Convention on Human Rights, and if a care plan facilitating such contact is lawful, whether that plan would be in C's best interests. Hayden found that Section 53A had little, if any, relevance to what was being contemplated for C in the particular circumstances of the case. No party was suggesting C should make arrangements with a street sex worker, and I anticipate that any practitioners that are facing these questions on the ground, I think that is also likely to be the case, that nobody is going to be proposing that P has contact with street sex workers. Mr. Justice Hayden concluded that Section 39 was drafted to protect against the exploitation of the vulnerable, and he said that the words of the statute need to be given their natural and obvious meaning. There's a paragraph from his judgment there, which I shan't read out. You'll get the slides after the webinar, but it's a useful excerpt from the judgment. to have. On the basis of his analysis, therefore, Mr. Justice Hayden found that what C was seeking was not in principle going to lead a care worker to be committing a criminal offence. There wasn't a care plan before the court at the time the determination was made, and Mr. Justice Hayden noted that he would have to consider whether it is in C's best interest to pursue the course that he had set his mind on, and he commented that he would have to have in mind that it will never be in C's interest to put himself or others at risk. And I think that's really key, those comments, when care plans are being contemplated around this issue. The judgment itself is some 96 paragraphs long. However, I would recommend reading it in full for anyone who is tackling this issue on the ground. I've not been able to do it justice on the exceptionally brief summary above due to the time constraints of this webinar. And as judgments go, it is quite an interesting read. The Secretary of State took the position that he wished to discourage prostitution and sought to appeal Mr. Justice Hayden's decision. Within the judgment, Mr. Justice Hayden noted that Parliament has not criminalised prostitution and it remains legal. And as such, the Secretary of State is trying to discourage that which the law actually allows. So the appeal was allowed on the basis that there was tension between general policy and the court's interpretation of Section 39. Mr. Justice Hayden didn't consider that in the case of AB, the same issues had been considered, and as I said before, the court wasn't asked to go into any real depth as to the scope and reach of the law, but Mr. Justice Hayden did acknowledge that because of the judgment in Mr. AB, there may be two contradictory views on Section 39 within the division, and hopefully this appeal will give us some answers and a way forward as to the legality of the circumstances that are contemplated within these cases. So in terms of where that leaves us, on Hayden's analysis, if P is deemed to have capacity to engage in sexual relations and to make decisions about contact with sex workers, it will not be illegal for his carers to facilitate access to sex workers in accordance with P's wishes, subject to the care plan being in P's best interests, and it must not put him or her at risk or others at risk. And the sex worker identified must not fall within the scope of Section 53A. Theoretically, a best interest decision could be made around contact with a sex worker if P had capacity to engage in sexual relations but lacked it in relation to contact. The courts haven't been asked to tackle that as a specific issue yet, but I anticipate that it probably will come up at some point in the future. In terms of some practical advice, I would proceed with extreme caution if you're facing a case with these issues, and I would recommend seeking legal advice as soon as possible. We are always happy to provide advice on any issues of this nature, so please don't hesitate to contact our clerks in chambers if you need any help or support. Our contact details will be on the slides, and obviously they are on the website as well. So I shall just pop my video back on and say hello to everyone again. We are now in the hands of the Court of Appeal to see what they say in the case of WC, but in the meantime, as I say, we are here to help. So please do get in touch if you've got any questions or you need any help or support on managing issues that you're facing. That's it from me on the sex worker point. So I will hand over to Jade from PSG to take you on to the financial bit of the presentation. As I say, any questions, bob them in the chat function and I will answer them as Jade's doing her bit of the presentation, and her colleague Tom will answer any financial questions if they come up during the course of Jade's part of the webinar as well. So thank you all for attending, and I'll hand over to Jade.
Thanks, Laura. I'm just going to try and share my slides, if you bear with me. Okay, so my part of the presentation is going to be on safeguarding assets and settling outstanding care debts. So I'm Jade Price. I'm a solicitor in the Court of Protection Department at Price, Slater, Gawne Solicitors. We deal with a variety of court of protection matters, including deputyship applications for local authorities and financial safeguarding cases. As Laura said before, I'm joined by my colleague Tom Young. He's the head of the Court of Protection Department at Price, Slater, Gawne, and he'll be answering any questions you have in the chat function. So this webinar will be split into two sections. The first will be focused on financial abuse and safeguarding assets. The second will be focused on the Court of Protection, deputyship applications, and how deputies can deal with outstanding care debts. So in terms of the financial abuse and safeguarding assets, we'll look at an outline of the statutory framework, identifying different types of financial abuse, mental capacity, an explanation of the available remedies, and tips to help deal with financial abuse cases. The Department of Health's No Secrets Guidance 2019 sets out how commissioners and providers of care services should protect vulnerable adults. No Secrets was repealed by the Care Act 2014 on the 1st of April 2015. The Act contains replacement and mandatory requirements around adult safeguarding. The Care Act 2014 sets out a clear legal framework for how local authorities and other parts of the system should protect adults at risk of abuse or neglect. So you can see here, section 42, section 1, creates a statutory duty to make inquiries. So the section applies where a local authority has reasonable cause to suspect that an adult in its area has the needs for care and support, is experiencing or is at risk of abuse or neglect, and as a result of those needs is unable to protect himself or herself against the abuse or neglect or the risk of it. The local authority must make whatever inquiries it thinks necessary to enable it to decide whether any action should be taken in the adult's case, and if so, what and by whom. Definition of, under the Care Act 2014, of abuse, it includes financial abuse, and for that purpose financial abuse includes having money or other property stolen, being defrauded, being put under pressure in relation to money or other property, and having money or other property misused. There's various different types of financial abuse, but some of those are outright theft or fraud, sometimes with the vulnerable person's knowledge, and where they lack capacity, acting beyond or without authority or outside what is in the person's best interests. Lacking capacity is not a requirement for financial abuse, but it can be a decisive indicator and will certainly impact on the options available. There's undue influence, moving assets or property, leaving a person without access to funds, gifts or loans, or changing a will. Now, there's a different legal framework in Wales, but many of the provisions do mirror the Care Act. One of the most significant differences are the adult protection and support orders. If you want to contact us separately, you can do, and we can give some more information on the Welsh framework for you. When we think about mental capacity, we need to remember the fundamental principle that it's time and issue specific. You should always consider this first if there's a financial safeguarding alert. You need to ensure that you're keeping a record of everything. And if the person does retain capacity, then it doesn't mean that there still can't be reason for further safeguarding action. Section 47(2) places a legal duty on the local authority to take reasonable steps to prevent or mitigate loss or damage to property in cases where they have been provided accommodation under the Care Act or when the person concerned is admitted to hospital. So where there's a reason to doubt capacity, then the local authority should be assessing this at an early stage. If they lack capacity and there is someone appointed, then the local authority needs to verify this. If nobody is appointed, there needs to be a stop on further financial activity and steps taken in order to protect the person's assets. And also think about the interim measures that we're able to take and the involvement of P. It's not just about protecting them from financial abuse. The Care Act also identifies 6 key safeguarding principles. They're empowerment, prevention, proportionality, protection, partnership, and accountability. So empowerment, people should be supported and encouraged to make their own decisions. This should be done by making services more personal and giving people more choice and control over decisions. We should be asking people what they want the outcome to be, and this means that the adult is asked what they want to happen and services can plan safeguarding around this. Empowerment, people being supported and encouraged to make their own decisions and informed consent. Prevention, it's better to take action before harm occurs. Proportionality, the least intrusive response appropriate to the risk presented. Protection, support and representation for those in greatest need. And partnership, local solutions through services working within their communities. Communities have a part to play in preventing, detecting and reporting neglect and abuse. Accountability and transparency in safeguarding practice. The Office of the Public Guardian, we always encourage a referral to the Office of the Public Guardian where somebody has concerns regarding lasting power of attorney or an EPA. So the Public Guardian was introduced by the Mental Capacity Act in 2005 and it's responsible for the administration of the registers of LPAs and EPAs and of deputies. It only supervises deputies but can investigate attorneys where concerns are raised. They have court visitors who can go and see on the ground what's happening, you know, in families' properties. They can go and get statements from various people about what's happening. They have no direct powers or enforcement or sanctions, but the number of investigations are increasing. So yeah, as I say, we always encourage people to tell the OPG if there are any issues that they think there are with lasting power of attorneys or EPAs, and then they can investigate that as soon as possible. So remedies for financial abuse, we've got revoking an LPA or removing a deputy. Appointments of a professional deputy. We've been involved in many cases where the courts either revoked an LPA or removed an existing deputy. PSG Trust Corporation acts as a professional deputy for many individuals and have been appointed by the court as a replacement in matters where an LPA has been revoked or where an existing professional or lay deputy has been removed. Obviously we can report to the OPG and or to the police. There's civil recovery, a claim on the bond, recovery of items or property, and liability of professionals involved. So some tips for dealing with financial abuse. We would say assess capacity early and continue to assess it. Don't make any assumptions. Obtain all your evidence and verify documents where possible. So that might be an LPA or a court order, appointing a deputy. Check balances of funds that are being managed by care providers. Make sure you look at outstanding care fees or personal allowance, and check the appearance of the person, including any comments that they make. So moving on to the second part of the webinar, So in terms of our role and the Court of Protection's role, the Court of Protection, the Mental Capacity Act established the Court of Protection, which has jurisdiction to determine matters relating to mental capacity. The Court of Protection is in Holborn, London, but there are regional courts that can hear cases as well. The courts deal with both financial and welfare decisions. The principles in respect of capacity and the Mental Capacity Act apply the same, but there are differences in some of the procedures and common themes that arise. Financial applications are commonly determined on the papers unless the application is contentious or if there's a point of law to determine. The rise in the number of investigations by the Office of the Public Guardian has also seen an increase in the number of applications that they've made. So we're going to go through the role of the Court of Protection, the powers of the Court of Protection, the appointment of a deputy for property and financial affairs, the application process, and then how we can settle outstanding care debts. So the powers of the Court of Protection. The court will determine whether somebody has capacity to make a particular decision. If they lack capacity, then the court can appoint a deputy to make decisions on behalf of that person. They also have the power to remove a deputy. The court can make one-off financial decisions, such as whether a certain payment should be made or how a property should be dealt with, such as authority to sell property or authority to make a gift. The court can revoke and/or remove an attorney. This might occur when there's been an abuse or mismanagement by the attorney, or where there's a breakdown in relationship. The court can also determine whether an LPA or an EPA is valid. They can also authorise and approve a statutory will. This is where a person lacks testamentary capacity, but if a will was not made on their behalf, then their estate would not be dealt with in the way that they would wish. So, for example, if there's a person with a large litigation award who has never had any relationship with their biological father, if that person was to predecease their parents, then both biological parents would inherit his or her estate equally through the intestacy rules. It's unlikely that the child would want the biological father to inherit if he or she has had no relationship with him, and they instead wish for his or her stepfather to inherit part of the estate. The court will consider all of the necessary factors and decide whether they feel a statutory will would be in this person's best interests. The court can deputy to make future decisions on behalf of somebody who's been determined to lack capacity to make those decisions for themselves. The order appointing a deputy will confirm the scope of their powers and any restrictions. This can include either the restriction or authority to buy and sell property on that person's behalf. This includes minors where the capacity evidence suggests that they would lack capacity as an adult. This often arises in cases where there is a litigation claim on behalf of a minor, and as a result there are funds that require management on their behalf. The court will decide whether the proposed deputy is reliable and trustworthy and has an appropriate level of skill and competence to carry out the necessary tasks. In the majority of cases considered by the court, the deputy is likely to be a family member or someone who knows the person well. Where the case concerns a damages award, then the court prefer the involvement of a professional deputy. Under section 19(9)A of the Mental Capacity Act, the court can ask a property and affairs deputy to provide some form of security, for example, a guarantee bond to the public guardian. The court can also ask a deputy to provide reports and accounts to the public guardian as it sees fit. So the application process to appoint a deputy. We require evidence that the person lacks capacity to make decisions in respect of their finances. So we would normally request from the local authority or from a doctor a CoP 3 assessment be conducted. So it's a capacity assessment that will have various different questions to see whether or not that person does lack capacity at that time to manage their property and financial affairs. We fill in a CoP 1 application form, which has the general information about P. It will have their full name, address, and details of people close to that person that should be notified of the application. And a CoP 1A form, which has all of the financial information about that person. So we'd require information such as bank details, any investments, any debts, the overall financial picture, whether they own any property as well. There's also a COP4 deputy declaration, and an application fee of £365 is payable to the court, and once the court's issued the application. It normally takes around 4 to 8 weeks for the court to issue the application. Then we have to go and serve notices on P, which is a COP14 notice. We go and visit P and explain to them that an application has been made for a deputy to be appointed to manage their property and financial affairs, and P then has the opportunity to object to that. Other notices are, we send COP15 notices to at least 3 different people that are closely attached, so maybe family members or care providers, and they also then have the opportunity to object if they disagree with the application. Following the notice period, the application will then wait to receive judicial consideration, and the applications are usually considered on the papers, as I said earlier, unless they're contentious. So for example, if somebody did file an objection, then it may possibly go to a hearing. The application timeframe varies depending on how busy the court is, and it is possible to request that the court expedite the application in certain circumstances. So examples of where we have expedited applications are where, for example, an interim payment or final settlement of a litigation claim is due or has been received. In these cases, the money is most likely need to be spent on therapies or the purchase of a suitable property for the injured party. So it's important that the court considers these applications more quickly than other matters. You can also make urgent applications, but these are more rare and tend to arise where there are safeguarding concerns. So once a deputy is appointed, they can then consider and settle any outstanding care debts from P's funds. If funds are not readily available, then the deputy may consider the sale of P's property. As I said earlier, this is something that you do need to request specific authority for when you make the application. So it's important that if, for example, a professional deputy is going to make the application, that they're aware of all the, the finances and whether or not a property is in the picture. If there is authority to sell the property, then the deputy can do that if it's vacant and it's in P's best interest. And then from the proceeds of the funds of the sale of the property, we can then reimburse the local authority for the care debts. So Slater, Gawne Trust Corporation, who are appointed as deputy to many different people, have paid over 128,000 to local authorities in the past 12 months to settle the outstanding care debts. So a summary of work that we can assist with. So as I said before, we make applications to appoint a deputy for property and finances. That can be for lay deputies, and also applications for professional deputy administration. PSG Trust Corporation can have a number of benefits compared to an individual, with it being professional, and as I said earlier, when litigation claims are involved, litigation awards, the court does tend to prefer a professional is appointed. Applications for specific approvals or authorities, so property purchase, gifts and certain investments, revoking an LPA, witness statements on professional deputy costs, local authority and NHS care funding disputes, benefits disputes, personal injury trusts, statutory will applications and welfare proceedings in certain circumstances. So we've got the chat function there if anyone does have any questions about any of that. And I think I'll pass back on to Laura.
Thanks very much, Jade. I've only seen one question come in through the chat function, so if nobody else has anything else, then thank you very much for attending. Like I say, the slides and the link to the webinar will be circulated hopefully tomorrow. And if you think of any questions that come up after the event, or if you need any formal advice, all our contact details are on the slides and what have you, so please feel free to get in touch. So thank you very much for attending, and we'll let you get back to your day. Thanks very much.
Thank you.